my name is Monica Patankar. I'm an attorney and partner of my own law practice, Patankar Patankar PC, in Aurora, Illinois. I'd like to invite you, all of our MMC members, to understand more about the estate planning process. I'll be hosting a virtual conference where you'll understand what it takes to protect yourself and your family during these uncertain times. Join me for our virtual estate planning conference. Thanks. Hi, my name is Monica Patankar. I'm an attorney and partner of my own law practice, Patankar Patankar PC, in Aurora, Illinois. I'd like to
नमस्कार मंडळी, मी भरत नाईक, महाराष्ट्र मंडळ शिकागो तर्फे आज एक स्पेशल प्रोग्राम सादर करत आहोत. त्याचं नाव आहे एस्टेट प्लॅनिंग अँड कोविड-19. या प्रोग्राममध्ये खूपशे जे टर्म्स आहेत हे लीगल असल्यामुळे आजचा प्रोग्राम आपण इंग्रजीमध्ये करणार आहोत. सो आता मी भाषा बदलतो आणि इंग्लिशमध्ये बोलतो. वेलकम टू द स्पेशल सेशन ऑर्गनाइज्ड बाय MMC. टॉपिक इज estate planning and COVID-19. Estate planning a topic is very, very important, but it's ignored by many people. So the intent of today's program is to actually bring estate planning more real and to help you understand how you can get your estate planning done. So to do this, I'm very pleased to present Monica Patankar and Ameya Patankar from Patankar, Piccone and Associates. We are very thankful for having them here. Let me introduce both them as well as their firm first. Piccone Patankar is a law firm in Illinois, Aurora, Illinois, that focuses on estate planning, real estate buy and sell representation, tax matters, and other areas of law. Piccone and Patankar is a very highly valued sponsor of both Maharashtra Mandal Chicago as well as Maharashtra Mandal Shara. In addition, Monica has served on the board of MMC for the past several years. So we thank them for their contributions and their continued attention to MMC items. First, Monica Patankar attended University of Notre Dame Law School, where she received her JD, and she received an LLM in taxation from Washington University in St. Louis. Ameya Patankar has a JD from St. Louis University and also an LLM in taxation from Northwestern University. So on behalf of both of them, I'm proud to present both. So I'll hand over the mic to both Ameya and Monica. Welcome to the program. Thank you very much.
Thank you so much. Thank you once again, MMC and Samir Sawant and the rest of the committee for allowing us to have this presentation today. I am attorney Monica Patankar of Piccone Patankar PC, and I'm here with my brother, attorney Ameya Patankar.
Good afternoon.
And we have a really interesting seminar for you today. We'll be talking about the basics of estate planning and how they're relevant today with everything going on with the pandemic and COVID-19. So in order to help you understand what's going on, we've created a PowerPoint presentation so all of you can follow along at home. Just give us a minute until we get into this presentation here. So this presentation is called Estate Planning Basics, presented by myself and my brother, Ameya Patankar. So our law firm, as Bharat mentioned, is in Aurora, Illinois, right off of I-88 and Farnsworth Road. So the first thing I'd like to start off with is a conversation with our moderator, Bharat. Bharat and I had a chance to talk yesterday, and he actually informed me that he's done his estate plan. So I want to ask Bharat a few questions. Bharat, are you there?
Yes, I am. Absolutely. Okay. Go right ahead.
Okay, so the first question I want to ask you is, how did you finally decide that it was time to do your estate plan?
It's actually a good question, because I, like many, have procrastinated for a long time. But as I was approaching the age of 50, the bubble of security that I had around me didn't seem like very strong as it did before. Unfortunately, I heard about many health issues from my friends back in India as well as here. And I started realizing that I need to start thinking about the future as well. So that was one of the more driving forces, my advancing age as well as my kids, and to see that, the hard-earned wealth that I've actually got, to make sure that it's actually handled in a appropriate and easy manner, if should anything happen to me.
Okay. Yeah, I mean, that's most of the time, that's what our clients basically tell us. So why do you think a lot of people don't think about estate planning? Why isn't it on their mind?
It's also another question, and I can speak from personal experience. I can't won't speak to the other people, but I would say broadly there are about three reasons. One is primarily lack of knowledge about what needs to be done. They feel that there's a complexity about what forms need to be filled, what's the process that they have to go through. So just a general lack of knowledge is one thing. The second thing is in my case especially was pure laziness. Really, I mean, it was just trying to put it off for no good reason. And the third thing is in a small way, I would say it's also about how much it is going to cost, where do you go to, who is going to help you out, etc. So I would say there are like three different buckets that you can put all these reasons in, but those are mine actually.
Okay, that's really interesting that you're sharing your personal story. So what do you think our community, our Maharashtrian community, MMC, or just the general community needs to know about estate planning?
Having gone through that, the one thing I can tell you is it's absolutely not as painful as I expected it to be. All right, so that is one main thing I have to tell you. The second thing is I would say is that people actually really need to get this done because there is a lot of rules that we don't are not aware of at the state level and the federal level. And honestly, your survivors, my survivors, should anything happen to me, either if I'm incapacitated or if I pass away, then it's likely that my survivors won't have the knowledge about what needs to be done. So, as a responsible parent and responsible husband, I felt that those items should be easier because they would be dealing with a lot of issues regarding my situation. So, I think that from a community perspective, what I would advise is if you get some responsible legal representation like Piccone and Patankar on your side, and if you have all the legal papers all understood, it's really not very painful. So you really need to just get it done. And once it's done, right? So there is nothing really you need to worry about on an ongoing
Absolutely.
basis. So
Absolutely. So I think that's one of the most common things I hear from my clients is it just scares them, quite honestly. When you think about estate planning, you think about dying or you think about sick people or old people, but as you'll find out from the presentation, it's really for anybody. And the time to do it is not when you get sick or after someone passes away. And right now we have a lot of time. We're all sheltering in place and we're seeing all these terrible things happening all over the world and in our state. So this is really the right time to be thinking about this. And I promise you it's not scary and it's extremely painless.
Yep, I concur with that, and I totally agree. Yes.
All right, great. So what we want to do during this hour is give you an overview of why estate planning is important. I will address why estate planning is important in today's climate with the pandemic happening all around us. We will teach you about the components of a comprehensive estate plan. Many of you heard of a will or a trust or a power of attorney. We're going to be talking about those documents extensively. And we'll be going through the scenario of what happens when you don't have an estate plan. If you don't have an estate plan and someone passes away or someone gets sick, what does someone need to do? Now, I just want to have a disclaimer out there that this presentation is for Illinois estate plans only. Each state has their own probate laws and estate planning laws. So if you are watching in a jurisdiction outside of Illinois or in another country, you would want to consult an attorney wherever you live. But this presentation is going to go over Illinois estate plans. And then finally, we'll end up with a question and answer session. So first, I'd like to start off with, how is estate planning relevant to COVID-19? So like many of you, I've been watching the news every single day, and the general consensus is we don't know who's going to get COVID-19. Okay, we are seeing children being sick, adults, elderly people, essential workers, non-essential workers. We just don't know who's going to get sick. So as of yesterday, the US had seen over 50,000 deaths. There are 946,000 people as of yesterday who are sick from COVID or infected with COVID. And that becomes a real problem. The time to create an estate plan is not when you get sick. So that's the misconception. The reason that I decided to do this seminar is that I thought about our community. There are a lot of people in our community that don't know what estate planning is. If someone gets sick from COVID and becomes incapacitated, for example, like if they're on a ventilator, it's too late to make an estate plan because that person can no longer make decisions. So let me give you a real life example. After the shelter in place went into effect, I got a call from a client, and that client's father was on a ventilator and he had become incapacitated. So he was unconscious. He didn't know what was going on. He couldn't communicate with anyone. And under the law, he lacked the legal capacity to make decisions. So the son, even though he's a blood relative, he has no authority under Illinois law to make his father's medical or property decisions because his father did not put any estate planning documents into place before he became sick. So I told the client that we would have to do an emergency guardianship. So unfortunately, emergency guardianships are very, very, very expensive, and they are very stressful for the family because the family has to come to court and tell the judge why they need an emergency guardianship. The problem is right now the courts are generally closed except for emergency matters. So this adds another layer of problems. So this father could have avoided this entire scenario by creating a power of attorney for healthcare and property before this happened. So why do you need an estate plan? A lot of people think that they don't need an estate plan. Many people think that estate plans are for old people or really rich people with mansions, or that they just don't need one. The truth is that an estate plan is for everybody. Everyone needs a different type of estate plan depending on their situation. So someone who is single and maybe has a job and owns a home is going to need a different type of estate plan than maybe a married couple who has a home, several rental properties, and has multiple children. So these two different scenarios, each person needs a different type of estate plan. So an estate plan protects your family and your assets if something happens to you. So right now, when you're healthy, you can choose the people that you want to make your decisions in advance of something happening. So when we're talking about an estate plan, we're not always talking about death. Okay, so some of the documents we're going to discuss today, they actually govern while you're alive, but you're incapacitated. So what we're doing is simply planning for your future. So a lot of people ask me, what is an estate planning? Or they'll call me and say, okay, Monica, I just need a will. I don't need an estate plan. So an estate plan just refers to everything. Think of it like an umbrella concept. So an estate plan refers to just the overall process. So the will is just one document in an estate plan. Your estate plan is a method for using and transferring your property and making decisions for your care during your lifetime. So usually when you work with our firm, depending on what you need, we generally create a last will and testament, a revocable living trust, a power of attorney for healthcare, and a power of attorney for property. Those are the four main documents. So the rest of this presentation is going to be talking about these documents, what they mean, and why you need them. So let's first talk about what is a will. Everyone has heard of a will. Maybe we don't know exactly what it is, but everyone's at least heard of the term. So a will is a legal document that takes effect at death. The will name an executor to wrap up your affairs. So if we have a married couple, usually we have the husband naming the wife and the wife naming the husband as the executor. And then if both of them pass away, we have executors to take over if something happens. So successor executors. Usually that can be a child over the age of 18 or any other responsible adult. Another important provision in a will is a guardianship provision. So what does a guardianship mean? Well, basically a guardianship means who's going to take care of your children if a married couple or just a couple passes away and leaves children. If you don't name a guardian in the will, there is a guardianship case that has to be filed by a family member or by a friend that could take a very, very long time. The other problem with not having a will and having children and not naming a guardian is that there could be a family feud. So if you have a lot of people that want to raise your children after you pass away, they could be fighting with each other for several years and take away from the main point, which is to raise your children and to make decisions for them effectively. So all of that can be avoided by naming a guardian for the children in a will. So the next common document is a revocable living trust. So the living trust is revocable because you can change it, you can take it away, you can replace it with a new one. It's fully amendable and revocable. So a revocable living trust, I kind of explain it. Okay, think of a candy jar. The jar is a trust and the candy in the jar are your assets. So after you create the trust, which is like the candy jar, we're going to transfer your assets into the trust. So the trust is a document which describes how you want your property managed during your lifetime and at death. So like a will named an executor, a living trust names a trustee. So if you have a married couple, the couple is both going to be the co-trustees of their trust while they're alive and healthy. If something happens to one of them, then the remaining person will be the sole trustee. And if both people pass away, then my clients will have named a successor trustee. Again, that can be a child that's over the age of 18 or another responsible adult. Now, the unique thing about a revocable living trust is that it's a private document. So no one is going to see this document. It doesn't get registered. It doesn't get filed anywhere. We do recommend that after a client signs a revocable living trust, they keep it somewhere in their house where someone can find it after someone passes away. But unlike a will, it's not filed anywhere. A will, under Illinois law, is to be filed in the county in which the person lived prior to their death within 30 days. So the will does become a public document after someone's death. However, the trust remains a private document. That's why it's very important. The other important thing about a revocable living trust is that it avoids probate. So for a couple or an individual that owns a house, we will transfer their house into the trust. So if it's a single person, it'll be their primary residence, or if it's a married couple, it'll be their marital home. And the other important thing about a trust is that we make sure that the heirs or your children or anyone else you want to get your that wants to get your money is conveyed the property in a timely manner. So as parents, you can decide to convey that property when children are 25 or 30 or 40 or 50 or whatever age you feel that your children would be responsible receiving this money. And now I'm going to hand the presentation over to my brother, attorney Amaya Patankar, who will be describing two other documents that are very important, and those are the power of attorney for healthcare and the power of attorney for property.
Thank you, Monica. So let's discuss first the power of attorney for healthcare. Now, this is a legal document that allows you to choose a person to make your healthcare decisions for you when you cannot make them for yourself. Now, the person you choose in your healthcare power of attorney will be called an agent. And this agent can make your healthcare decisions when your attending physician deems you as incapacitated, unable to mentally make your own decisions, or the agent can make your healthcare decisions right away if you choose that when you initially execute your power of attorney for healthcare. Now, the agent has a duty to act in good faith on your behalf, or they could be removed by a judge. Now, who typically acts as your agent? Well, typically an agent is your spouse or a good friend or a relative who you trust to make these important decisions for you. Now, you can't have co-agents, but you may appoint successor agents as backups in case someone cannot act that you have appointed as an agent in your power of attorney for healthcare. Now, the power of attorney for healthcare, this document must be created while you still have mental capacity, meaning you are still able to make decisions for yourself. Once you lack mental capacity, you can no longer create this document or modify this document if you've already executed it. You will decide the range of the agent's powers, making them either very broad or very specific on what you want your agent to act for you. The different examples that an agent can act on your behalf are healthcare and medical treatment decisions. They can make your end-of-life decisions, admitting you or discharging you from a healthcare facility that is treating you. They can also authorize an autopsy or donation of your organs for medical research. So it's a pretty expansive list of things that an agent can do on your behalf. And as we already discussed, they are broad or they can be very specific based on what you have designated. You can also limit the powers in your power of attorney for healthcare based on your personal beliefs and your religious beliefs. Now let's discuss the power of attorney for property. Now, this is a legal document that will allow you to give someone else, again, your agent, the ability to handle your money and make financial decisions for you. You must create this document while you have mental capacity, similar to the power of attorney for healthcare, as you cannot create or execute this document once you lose mental capacity. Your agent, who you have appointed, must also act in your best interest under Illinois law. And if abuse is found by one of your family members or a third party, the agent can be terminated from the power of attorney for property by a judge. It is possible that you appoint an agent who in the future becomes incapacitated themselves due to sickness or death. So you're always going to have successor agents in the power of attorney for property scenario as well, so that you will have backups in case your initial agent cannot act on your behalf. Also, with the power of attorney for property, you cannot have co-agents. So you will always have one person acting on your behalf at a time. Now, what can your agent under the power of attorney for property, what can they do? Well, they can buy or sell real estate on your behalf. They can pay your bills. They can even make contributions or withdrawals from a retirement plan. They can buy or sell stock in your brokerage accounts. They can even hire a lawyer to file or defend a lawsuit on your behalf. They can even run a business. So as you can see, it's a wide range of activities, and you can always limit the types of powers that your agent can do for you when you initially execute the power of attorney for property. And the last thing is that you can always amend or revoke your power of attorney for property or healthcare as long as you have capacity to make that decision. However, once you lack the capacity, you will not be able to amend or revoke these documents.
Okay, I'm back. This is Monica Patankar back on the PowerPoint. So now the big question is, what happens if I don't have an estate plan? So if someone passes away without an estate plan and they own a house or they have any assets, generally the client will call us and we'll have to file a probate estate. Okay, so if you live in Naperville and in DuPage County and you pass away without an estate plan, we'll have to file a probate estate in DuPage County or Kane County or wherever you live in that county. Probate estates are very expensive. Generally, you're paying a lawyer an hourly rate, and it generally costs several times more than it would cost to do an estate plan before the fact. Probate estate is monitored by the court, and generally it takes a minimum of 6 months at minimum for any heir or child to actually get this money. Again, like I mentioned, in a will, we have a guardianship provision. So without an estate plan, if someone passes away or a couple passes away and they leave minor children, those children could be living with a foster family for a while until a guardian is found and appointed by the court. So it creates a guardianship fight for the children. Another problem with not having an estate plan is that in the state of Illinois, your children can inherit money at age 18. So if someone passes away and their children are just on the border of being 18, that young child who's probably not very responsible yet is going to inherit your entire estate at age 18. And for many of you, that's a very scary thought. In our trust, like I mentioned, we can actually indicate at what age you would want your children to get the money. And generally speaking, 99% of our clients do not want their children to inherit the money at age 18. Another problem is that I can't tell you the number of times that I've signed these documents with my clients at the last minute. So I've been to nursing homes, I've been to the hospital, I've been to people's houses that are facing a terrible terminal illness. And that's just not the time for anyone to be signing an estate plan. Of course, we got it done just in time before they passed away, but that creates additional stress for the family. It creates additional stress for the person. And that situation really could have been avoided by someone thinking about it in advance. So the big question I get from a lot of my Indian American clients is, does my Illinois estate plan cover property in India? Well, the short answer is no. We're talking about two different countries. We're talking about the United States and we're talking about India. So if you have property in Illinois, you need an Illinois estate plan. If you have property in India, you need a similar estate plan in India. Since this is a presentation for Maharashtra Mandal, I recommend a lot of my clients to Bave and Company, attorney Srinivas Bave. His firm is located in Mumbai, and he works with a lot of my clients to create concurrent wills and estate plans that will take care of someone's property in India, even if they're living here. So you might be wondering, okay, I've listened to your presentation, and what do I need to do to create my estate plan? Bharat mentioned at the beginning of the conversation that created a real quandary for him because he didn't know how to get started. He didn't know what exactly he needed to do. So after the presentation's over, you can feel free to call myself or Amaya at 630-820-8877. We are open during the pandemic. We are an essential service, so law firm's an essential service. We're open Monday through Friday or by appointment on the weekend. Like I mentioned before, everyone needs a different type of estate plan. So after I have a brief conversation with you, I will tell you what kind of estate plan you need. I am offering a discount to MMC members. So after you decided you want to do an estate plan, we send you a questionnaire. We don't need any financial information. We just need to know who you are, who your children are, and who do you want to fill the role of executor, of trustee, of the agent, etc. We need a copy of your house deed if we're doing a trust, and we're transferring property into your trust. So after we get the questionnaire back from you, we draft all the documents and we send it to you to review to make sure that there's no changes. Then we set up a time to sign the documents. So right now we're able to do it over FaceTime or over WhatsApp. We can set up something with you like that. And then we sign everything. We record your deed in the appropriate county that you live in, and then finally return the package to you. So generally, depending on how fast you get us the questionnaire, we can pretty much do it pretty quickly, but we just need to make sure that we have all the information from you. So the one thing while Amaya was talking, I was thinking about many of my clients want to name agents for power of attorney for property and healthcare that are in India. So let's talk about the problem with that for the power of attorney for healthcare. First of all, if you are a married couple, you're probably going to name each other. So the husband's going to name the wife, or the wife's going to name the husband. And then after that, if you have minor children, you can't name the children to make decisions if you become incapacitated. So a lot of my clients will ask me, hey, can I name someone in Mumbai or Pune or someone that lives out of state or out of the country or whatever? Generally speaking, this is how the scenario plays out. Couple is in an accident. They're both in a coma at Rush Copley Hospital in Aurora. If you name someone in India, it's going to take them several days to get to the United States, to be at the hospital, to talk to the doctor, to make your decisions. Or it's going to take several days to communicate with Fidelity or any other financial institution. Now we add COVID into the picture and there is restricted travel. So I always suggest when you're naming your successor agent for the power of attorney for healthcare, you always name at least one person that's local, just so that the person that you've named in India can get here in time. So with that, you can contact us at our email, monica@picconipatankar.com or amaya@picconipatankar.com. Our website is www.picconipatankar.com, and there's our phone number. And we'll take it off presentation mode now.
We actually have a couple of questions that we've been asked that we'd like to go over.
Okay. So let's take care of those questions real quick.
So the first question that we received is, Monica, my children are above age 18 now. Can my children be the executor of my will, the trustee of our trust, and the beneficiary of our estate plan?
Yes, absolutely. So in any of these documents, the will, the trust, or the power of attorney, if you have a child that's over the age of 18, you can certainly name them as the agent for power of attorney for healthcare or property, or your executor or your trustee. So the main thing you have to remember is that you are selecting someone that you trust in a a time that someone needs to make decisions very well, that you're choosing someone that is responsible, you're choosing someone that understands the law, and you're choosing someone that is going to carry through all the instructions that you have for them in these documents.
Monica, now, what are the tax implications of creating an estate plan?
Okay, so creating a revocable trust does not have any tax implications. So there's nothing that needs to be filed with the IRS or anything like that.
Now, how do you decide at what age our children will inherit property from our estate plan?
Well, that's a very personal question. Generally speaking, you have to, your kids better than anyone else. So an 18-year-old, maybe your 18-year-old is really, really responsible, and you say, hey, if I'm passed away, I feel comfortable with my 18-year-old inheriting my 100% of my estate, all my life savings, and I know that they're going to stretch that money out during their lifetime and use it for good. If you feel comfortable with that, then go ahead and allow your children to inherit at 18. Generally speaking, it's a good idea to do a tiered distribution. That's just what we give our clients that option. Give your children a chance to be adults, give them a chance to go to college and go to graduate school if that's what they choose, and then allow them to have that money after you pass away at an age where you feel they would be responsible enough to manage it.
Now, Monica, can I make a charitable contribution in my trust?
Absolutely. So generally speaking, most of my clients will leave the money to their children or another family member. But if you have a charity that you feel is very important to you, you can leave a charitable distribution in your trust to an organization such as Maharashtra Mandar Chicago, and basically designate how you want that money to be paid out for programming or for anything else.
Does your law firm accept legal plans through my employer?
Yeah, absolutely. So our law firm does accept legal plans. The most popular legal plans that we accept are the Met Law legal plan, which is also known as the Hyatt legal plan. And we also accept the ARAG legal plan or ARAG legal plan as well. And depending on someone's employer, we will look up their coverage and tell the client what they are covered for. And sometimes it covers the estate plan as well.
How long does the estate planning process usually take?
The estate planning process is generally pretty fast. Of course, if someone's having an emergency, like I mentioned in my example, then that's going to happen really fast. If you are traveling out of state or you're facing an emergency, please indicate that to me so that I can, expedite the process. But generally, it takes about a week or so. If you get me all the information, we can turn it around in about a week. So let me look at some of the comments that are coming in here and see what other questions we have.
While you do that, Monica and Amaya,
yes.
just a quick couple of things. If you go off presentation mode, then the audience can see you. And a comment for the audience people itself. I think I'm just going to say this, that it's fair to ask both Amaya and Monica general questions about estate planning. But I would suggest that if there is questions which are very specific to your personal situation, that you actually ask them individually. So that makes the best use of their time, and as well as allows people to hear the answers which are common for everybody. So appreciate that. Please carry on, guys.
Here's one up here about 2 estate plans for 2. We already covered that one.
Yeah, so we're looking at the YouTube chat right now to see what questions we haven't covered yet. So
I can do this one.
Okay, so someone asked, do we need multiple trusts for rental properties? So generally speaking, we don't advise you putting rental properties into your revocable living trust. And the reason is that it becomes susceptible to creditors' claims. So if something happens on your property, on your rental property, and someone gets hurt, they can actually file a lawsuit and go after your entire estate. So what we recommend in the situation where someone has rental properties in addition to their primary residence, we recommend that they do set up a business entity like an LLC.
Let's see. Is there a citizenship requirement?
Okay, so someone asked, I don't know the citizenship status of anyone watching this presentation, but you don't have to be a U.S. citizen to create an estate plan. You can be a permanent resident. Basically, anyone that owns property in the state of Illinois should make an estate plan. And even if you don't own any property, the power of attorney for healthcare and property is certainly going to help you, even if you don't own anything, because you are giving someone the right to make your decisions regarding your healthcare and your property if you become incapacitated.
Can a friend from a different state use our services, or do they have to find a local law firm?
Yeah, so right now, We are Illinois attorneys. So if you have a friend watching this presentation in a different state, they need to contact an attorney in their state. Okay, so someone asked, besides the house deed, what other documents are required for the estate plan? So we, again, like, I don't need any of your personal financial information. Obviously, that is confidential for you. So I just need to know your name, who you're married to. I need to know the names of your children, how old they are. I need to know where you live. If you own a business. So if you own a corporation or an LLC, I need to know that, because I need to make sure that we are transferring the ownership of that business to your children or your heirs if something happens to you. And then I just need a copy of the deed for your primary residence so that we can include that into the trust.
Looks like we got everything here. That's it. There's nothing else.
Okay, and now when I go over a trust, if someone, if there's a situation where there's one person in a married couple situation where they're very highly likely to get sued, what we do is create a different type of estate plan for you that protects against creditors' claims. So if someone is going to call me after the session and they are in an occupation where they are likely to get sued, make sure you mention that on the phone call, and we will advise you further on how to make sure to protect your assets.
Monica, are there any maintenance fees for the estate plan?
Okay, so one question that we got on the YouTube chat was, are there any maintenance fees for the estate plan? No, there are not any maintenance fees. So after you create your estate plan, you're basically just going to keep it with you. The only time it needs to be updated is if you sell the house that you're currently residing in and that we have recorded your deed into the trust, and the trust is holding the deed to your house, and you sell that house, then we will have to re-record the deed after you sell it. Or if your children become adults and you want them to have a role in your estate plan, you want them to be the executor, or you want them to be the trustee, or you want them to be the agent for power of attorney for healthcare and property, then of course, after they turn 18, then we would be able to update your estate plan to give them a role.
Monica, how does one get their brokerage account or a bank account into their trust?
Okay, so someone in the chat asked, how do they get their brokerage account or their bank account into the trust?
Stocks, funds of that nature.
Okay, absolutely. So basically what we do is the first thing we need to do is create your trust. And then after we create your trust, you're going to go to the brokerage company, if it's Fidelity or E-Trade or wherever it's at, and then your bank, Chase, or whatever bank that you bank at, and you're going to talk to that institution, and then you're going to update your beneficiary designation to make sure that you're naming the trust as a beneficiary if that's what you want to do.
Monica, can you go over quickly what happens if somebody does not have a trust and they already have beneficiaries in the state of Illinois?
Okay, so if someone only has a will and they don't have a trust, and they pass away and they have children, then we will have to probate the estate, because really the only way to avoid probate generally is to create a trust and put your house in the trust before someone passes away.
And how long does the probate process typically take for the beneficiaries to inherit the property from somebody who's left in the property, like their parents?
Okay, so the question is, how long does it take for the probate process? Again, we don't want anyone to go through the probate process. It's very stressful. You don't want to be going to court every single month to have some judge approve the assets that you are entitled to. However, it does take a long time. Generally, it takes over 6 months, if not years, to get that probate estate closed.
Now, if you move to another country, what happens to your estate plan?
Well, if you move to another country, you want to make sure that you have some kind of estate plan in the country that you're moving to. And if you are still owning property in the state of Illinois, then you can keep your Illinois estate plan to make sure that the property goes to the proper heirs.
A couple of questions there, guys. One question was asked whether the presentation that you shared, is that going to be made available to the people who attended?
Yeah, we can do that. I can talk to Samir and the IT team here to figure out how we can do that. Absolutely. And I
Okay,
know a
great.
lot of people, I know a lot of people on this presentation have very personal questions and they're not comfortable sharing them on YouTube. So everything that we discuss, every client that I've ever had, this is a completely confidential process. There's a concept called attorney-client privilege. So anything you tell me, I can't reveal to anyone unless you give me the permission to do so. So everything that you tell me stays with me. It stays with our law firm. This is a very professional process. We genuinely care about our community. We are longtime members of MMC. I know many of you personally, many of you come up to me at programs or chat me individually, and I'm just so happy to help you. So I'm just so thrilled to be giving this presentation with AMEA to our MMC community during this very difficult time in our country. I hope all of you are safe. If any of you are sick or anything, we pray for you, and please reach out to me individually if you need anything.
Yeah, and as a Maharashtra Mandal executive committee member, I completely concur with that, Monica. We appreciate your support all the time and as well as your participation. So there's no question about that.
Thank you.
So we do have a few more minutes for some questions. I think there is some, if you don't mind, we'll just ask, I'll just go to the chat window and look at some ones. There is one about stocks and funds, if those are also included in your trust.
Yeah, so I kind of briefly touched on that. So the first thing we need to do is create the trust. So once the trust is created, we've kind of created like the entity that's going to hold your assets. Okay, so when someone passes away, you can choose where you want the assets to go. So after we create the trust, what you're going to do is go to your financial institution. If your stocks are with Fidelity, you are going to contact Fidelity and say, I want my beneficiary to be my spouse, but if my spouse and I both pass away, then I want my beneficiary to be my family trust. So what that means is that those assets will go into the family trust, and then they'll be divided to your children or your heirs at the ages that you indicated in the trust.
One question that I see here, there's a couple. One says that Illinois allows natural heirs as the beneficiary. Does one need a trust? I'm not sure if you answered that one, so I'm just going to repeat that.
So if you don't do these estate planning documents, your estate goes into probate, and under the probate process, the assets would be divided under intestate succession, which I won't go into detail on that because that's a whole nother topic. So the problem with that is that maybe you have some children that you had a falling out with, or you don't want specific people to inherit something, or maybe you don't have children and you wanted that money to go to a charity, or you wanted it to go to a family member. The intestate succession law and what you wanted is probably not going to be the same. So to answer your question, it's probably better that you write down exactly what you want so that the law doesn't tell you what's going to happen. Oh, someone asked, what is the cost of this process, the will and the trust? So for MMC members, we are offering a discount right now. There's no I'll have to talk to you about your situation and then quote you a fee, but I'll make sure to work with everyone based on their financial resources.
Oh, if somebody moves out of the county, what happens then? They moved out of the county, not to another.
Oh, someone asked if someone moves out of a county, not another country. So that's okay because you are still in the state of Illinois. So if you move from Kane County to DuPage County, it's okay. If your trust had your house recorded and you lived in Kane County, then upon the sale of your home, that house would come out of that trust. And when you buy a new house in DuPage County, then your new house would go into your trust. So the county part of it really doesn't matter.
One question here, and I think I might have to rephrase that. It's asking whether a will or an estate plan is more flexible. Which document is more important? I'm not sure, but you can probably answer that, or it could be whether the will or the trust is more flexible. That also could be a part of the question, because that is a question that I had several years back when I was going through the process.
So the estate plan refers to the entire process. So just think of the estate plan like an umbrella. The estate plan is not a document. So the umbrella is the estate plan. And then we have various documents that come from that. So one is the will, another one is the trust, and then we have the power of attorney for property and the power of attorney for healthcare. So if you own a house and that's not in a trust, generally we would have to probate the estate to make sure that house goes to your beneficiaries. So in terms of flexibility, I don't know if they're trying to say, is it, are you able to amend it? You can amend a will and you can amend a trust at any time. So in fact, in our will, it says I can revoke this will at any time. So you can update it. Generally, you're going to update a will and a trust during your lifetime when your children become adults, or maybe your children are studying abroad, or they decide to move out of the country and you've named them as a trustee or an agent for the power of attorney for healthcare, but now they live in China or they live in India, and it's just not feasible for them to fit those roles. So at that point, you're going to update it. So both of the documents, all the documents that I've mentioned, are fully amendable, fully changeable. You can revoke them, you can keep them, you can take them away, you can do whatever you want with them.
I suppose there is a related question up there which probably answers there. Is there a difference in ownership transfer between a will and a trust?
I don't know what they're trying to say.
Okay.
Yeah, I'm not sure what that's referring to. So
They can call us directly.
Yeah, they can call us. Okay, I think they're probably
Under-
referring to maybe when a trust owns a house. So for most of the clients that we work with, if they're a married couple or even if they're a single person and they own a home, we create a will, a pour-over will, and then a revocable living trust. So when the house is transferred into the trust and the house is sold, the title company or the attorney that handles your sale is going to remove that house from the trust because you're giving it to the new owner. And then when you buy a new house, we're going to re-record that deed back into your trust. So now your trust is holding the home that you're actually living in.
Okay.
And if any of you have rental properties, when you give me a call, I can talk to you about creating a business entity as well. So that is a presentation for a whole nother day, but we can certainly help you with any rental property situations as well. And well, someone asked, will the estate go into probate even if there is a will? If they own a house, generally, yes. So the will is not going to protect, just having a will is generally not going to protect against probate. So for someone who has a family, has a home, has children, or even an individual who owns a home, doing a trust is very beneficial. It doesn't cost that much more money, and that you can have just the confidence in knowing that your livelihood and your children and your beneficiaries are protected. Okay, someone asked, can an estate be formed after a person is deceased? The answer is no, because we cannot have a dead person or someone who is incapacitated. We can't literally hold their hand and have them sign something because they don't know what they're signing. So one of the basic requirements in the state of Illinois is that someone has to have the capacity to understand what they're signing. So back to my example of the son who had their father on a ventilator in the hospital, that father was unconscious. So at that point, he couldn't sign any of these documents, and it wouldn't be valid under Illinois law. So that was the point of my presentation, is that you need to create these documents now while you're healthy, while you know what's going on, not after someone has passed away. You cannot create these documents. Then it would go into the probate process, generally. Okay, so people are asking me kind of personal questions now. So I think that that is it, unless you can think of something else, Bharat.
No, I think this is good. I think if we've gone to the chat window, I glanced through that as well. But as you said, if there is questions after this, you have shared your contact information and the presentation files. So Sameer also asked me about sharing your presentation, and which we will. So if you would, we'll just work together to make it available to the listeners. I think that would be very valuable. But in short, I think this is extremely valuable. I think the level of the presentation is exactly what it needed to be. And if I'd seen this several years back, I would probably act a little bit more sooner than I did. So I do appreciate all of that. Any parting comments before I close off? Because I think we have got a few minutes more. But looking to you to see if there's any more comments from your side.
Okay. Well, I mean, feel free to visit our website, www.piconi-patankar.com. We are a family-owned law firm. My brother, Ameya Patankar, is one of the firm partners. Gary Picconi is another partner. And he is very supportive of Maharashtra Mandar and the Indian American community. And my mom also is on the administrative team at our law firm. So it's a family-owned business, and we really treat our clients like family as well. So if you have a very personal situation, just know that you are in good hands with our law firm. We'll take care of you like our family.
And I think if you correct me if I'm wrong, Monica, but you said yours is the only Maharashtrian-owned law firm in the state of Illinois. So that is actually
I don't
pretty
know.
good.
That might be a very broad statement, but certainly we are probably the most the Maharashtrian-owned law firm, probably in Kane County and DuPage County. So
Okay.
we're
All right,
very
good.
very supportive of the Indian American community and Maharashtra Mandar.
Right, right. Okay, very well. Then I think if all the questions are there, they're committed. I do want to take another minute to thank you again for your time on a Sunday. I know this is Sundays can be a time for relaxation, so taking the time out to prepare and have this presentation, we definitely appreciate you from on behalf of Maharashtra Mandal. And all the listeners, thank you for attending as well on your Sundays, because we had a viewership, listening to people close to about 110, which is extremely good participation. I hope that all of the people listening got some really valuable information from this. Personally, also, I think in addition to what Monica and Ameya presented, if anybody wants to ask me any questions about, like what I went through from a thought process perspective, etc., I'll be more than happy to talk to you guys and answer on a more personal level as well. But again, in closing, Ameya and Monica, thank you very much for your time.
Thank
Really
you so much.
appreciate it.
Thank you. Thank you to
Okay.
MMC for allowing this. Thank you so much.